My name is Richard Gadzapo with the Tennessee Human Rights Commission. We're glad that you joined us here this afternoon. And I want to assure you that you are in for a great treat from our presenters. And the subject for discussion is what you don't know can bite you. Let me share one story that I just shared with Mr. Bruce a couple of minutes ago. The Tennessee Human Rights Commission, we enforce the Tennessee Human Rights Act and also the Federal Fair Housing Act regarding housing issues based on race, gender, and all those protected classes. A lady called our office to file a complaint, I think somewhere last year. And she's been living in this apartment where, for some reason, later on we found out that she was just not technically a good tenant. She failed to pay her rent on time. She was supposed to transfer the electricity bill to her name. And for almost a year, the landlord was pestering her to make that change. She failed to do that. And because she was not paying her rent on time, the landlord decided to evict her. Well, guess what she did? She called the Tennessee Human Rights Commission, and we were able to establish jurisdiction that we can investigate this case. One of the investigators calls the landlord to let him know that a complaint has been filed against him. And he said, "Who did this?" So the investigator mentions the tenant's name. And he said, "Thank you. I know what to do." After the phone call, the landlord calls the electricity company, and your guess is as good as mine. What do you think he did? He cut off the power. So the lady calls the Tennessee Human Rights Commission back. "My landlord is retaliating against me." That case settled for $10,000. Initially, we were going to dismiss the case because she was not paying her rent. But the action that he took was considered as retaliation. What you don't know can bite you. Just last month, reasonable accommodation to be allowed to keep a pet. Not a pet, but an emotional support animal. Long story short, $20,000 that case was settled for. What you don't know can bite you. But I'm glad that you are here this afternoon, and we have two of the most seasoned presenters in the state of Tennessee with us. I believe they are no strangers to you. Carol, Gish, and Tim are not strangers in Tennessee when it comes to tenant landlord issues and the Fair Housing Act. So you have their bio in the bulletin. I'm not going to bore you much more with that, but what I want to emphasize is that you are in for great knowledge. And if only you will practice what they share with you, you will not regret. I present to you the most seasoned presenters this afternoon.
All right, here's what we're going to talk about: the Fair Housing Act, the landlord-tenant law in Tennessee, and particularly, I think, reasonable modifications and reasonable accommodations under the Fair Housing Amendments Act. If there are any differences with the state act, Richard, raise your hand and tell everybody what they are when we get to them, okay?
Yes, ma'am.
Okay. There is this caveat at the beginning of every PowerPoint that we have. This caveat is placed in any of our products by contract with HUD. And what this says is that they're not responsible for what we put in here. So with that said, the Fair Housing Act, rights and remedies. Protected class.
Okay, for those of you that are new to this or semi-new to it, you need to be aware that the Fair Housing Act only covers 7 categories. It doesn't cover every sort of discrimination that exists out there. And in order to fall under the Act, it has to fit into one of these categories. We'll go through the categories now and explain to you roughly how they've been interpreted and how broad or narrow they're construed, and try to give you a feel for what kind of issues fall under the Fair Housing Act. Most of them are the types of issues that you probably already have in your mind about what's wrong and illegal and discrimination and disparate treatment of individuals or groups. But some of them aren't so clear-cut, and hopefully we'll make it a little clearer for you today.
I think pretty much the traditional class that we are all just historically familiar with is discrimination based upon race. And that would include discrimination directed against persons who are Caucasian, persons who are African American. Any class that you have would have really the same protection as the others. Color, sometimes housing providers can differentiate how they're going to treat somebody by the color of someone's skin, whether it's dark, whether it's light, or maybe something in between. So you're apt to have 2 things maybe going at the same time. You might have race and color, both as protected class within one complaint, or you could have maybe national origin thrown in with that too. I guess it's important to understand that in some of the cases that we get, the individual complaining is alleging more than one protected class. And sometimes they're close together, like race and color might be, or color and national origin might be, and sometimes they're entirely different. I've had housing providers that would discriminate against a black, female, African American woman because she fit the stereotype of their target audience. And this happened to be particularly with some of the bad loans that our speaker immediately preceding us had with one of the other entities that he so nicely talked about, Wells Fargo.
I think it's really handy for you that are new to this, if you look at this list, to realize that it comes from history. And the first 4, I believe, were all done in one fell swoop in 1968. Then sex was added later on during the women's movement. Historically speaking, familial status and handicap were added after that. So it gives you an idea where they came from and why, if you keep them in that mindset. Also, about the first 4 or 5 categories, until you get to familial status, as Carol pointed out, they work both ways. All those do. You can't discriminate against someone that's white. You can't discriminate against someone that's black. You can't discriminate against someone that's Catholic. You can't discriminate against someone that's Muslim. You can't discriminate against someone from Spain. You can't discriminate against someone from Croatia or the United States, or male or female. And it doesn't matter who the discriminator is. A female can discriminate against females. It's possible to be done. And I like to tell the story about I had a blind client who came in, had a dog, and wanted to have a waiver of the pet deposit. The landlady was also blind and wouldn't waive it. But it's still discrimination despite the fact that she's blind also. So those first 5 work both ways in all contexts. There's no way to bust them up separately. Now the last 2, familial status and handicap, to qualify for those you have to fit that category first. Folks that don't have a familial status or a handicap status are not covered by the Act. Other than that, the first 5, every one of you in here fits it one way or the other. Okay?
The last 2, maybe you do, maybe you don't. I think what's important about these last 2 is they're not visible, and generally the other 5 are. If you see someone, you can make some assumptions about them. I was going to call on you for that. Okay. Richard wants us to keep it rolling and not call on him. He wants us to state that under the state law, creed is also a protected class. So.
Yeah, you'd be aware that there's a national Fair Housing Act, and then there's the state Human Rights Act, that are essentially the same except for a few variations, and creed is added to this list in the state list.
Under familial status, it's going to be someone who is going to have minors that either need to come and live with them, maybe their children are in foster care, or it may be a mother-to-be who is discriminated against because of familial status, because she's pregnant. Maybe somebody won't put her on the waiting list, saying, you come back after the baby is born. It could be a grandmother who has written consent for the children to be with her, and management objects to that. It could be, I don't know, foster mother with foster children. All of those would come under the protection of familial status if there were a difference in treatment directed toward them because of the children, because they had children. Handicap status, Nadine alluded to this a little bit when she was talking about hoarding with a D. You can have, it's a physical or mental impairment that substantially limits one or more daily life activities. So you've got to have a substantial impairment of one or more daily life activities, a record of having it, which is what she discussed, or the other aspect of this particular protected class that she discussed is maybe not having any of that, but the housing provider or the provider-to-be treats the individual as if they were a person with a disability. In other words, getting inside the mind of that housing provider, it can be pretty difficult. But those are your 7 protected classes. Conduct that you think of traditionally associated with discrimination, example, you have to live in the back because of who you are. If that were directed towards someone because of race, if it were directed towards someone because of any of the other protected classes, that conduct would violate the law also. So the act, the conduct that violates the law because of, is going to be the same for really all of the protected classes. The only difference would maybe be with handicap status when you talk about reasonable modification and reasonable accommodation. That is really singular to persons with disability only.
I think it's kind of good for the big perspective on this is to realize the list we have up here is from the Federal Act. And Richard explained to us, just pointed out that the State Act adds creed to it. Localities can add categories also, and other states have done different categories also. And you'll see some of the most common ones would be gender or sexual orientation, or one that you see in some states and some locales is source of income. So that would be folks that have Section 8 vouchers cannot be discriminated against. Now here in Tennessee, all we have is these and creed, and if you're going under the Federal Act, all you've got is these 7. But when you hear about other laws in other states where they're talking about these other issues, it's because they've added other categories to their list.
You may have some municipalities also that have ordinances, fair housing ordinances, and they may add more categories too. It can be, without getting into the ability of a municipality to promulgate a fair housing ordinance, they really don't operate with the depth that the federal or the state act do. The state and the federal act are really able to get money damages for the victim. And generally, ordinances can't do that. Ordinances proceed to fine for violation of the law, and that fine goes to the municipality rather than to the victim, if that makes any sense to you. Because that's really getting too far down, I think, into things. Anyway, protected classes, familial status, we talked about that. Handicap, we talked about that. Inquiry of disability. Understand that when this law was passed, Congress also said to HUD, you make regulations that back up the Fair Housing Act. And the courts give those regulations what's called extreme deference. Inquiry of disability is one of the regulations that HUD made. And what it means is that housing providers cannot inquire about a person, the nature or the severity of a person's disability. You can't do that. If you do that, you violated the act and the regulation. There are some instances when you can act and ask what the disability, if you have a disability, but you still can't ask about the nature and severity of it. So, for example, how many people are familiar with that subsidized type of housing, 811, that's specific just for persons with disabilities? Okay. You can't qualify for that sort of housing unless you are a person with a disability. So that would be a logical question to ask. You can ask about current illegal drug use, and you can ask about conviction of illegal manufacture of a controlled substance. Current illegal drug use is not a protected class. A drug addict who is recovering is a protected class.
Another category that comes up in people's minds quite often because they confuse it with the fair labor laws is age discrimination. If you're, it's off the screen now, but age is not a protected class under the Fair Housing Act. Where you run into problems with it is probably the familial status, because a lot of the seniors only places do not allow children. We'll get into the exceptions on that later on, but I wanted you to be aware that there's a difference between the labor list of protected classes and the housing list of protected classes.
You can see up here some of the other questions that you can ask. Obviously, qualifications, eligibility of preference for persons with disabilities, meeting the requirements of ownership or tenancy. In other words, having enough income to pay for the rent. Markets covered.
Yeah, one more point on that. If we have any manager types in here, I know in the past there's been some forms that were given out for folks that ask for a reasonable accommodation or claim of disability in housing. And those forms ask for a statement from the doctor as to what the disability is, and those aren't proper. I don't know if they're still rolling around. Do you see those anymore?
Honestly, we do still see those forms.
Okay.
We will see statements from managers that, yes, this is an example. Maybe when they're asked about whether or not an assistance animal, someone that is there for the emotional support perhaps of an individual, or maybe trained to pick up items off the floor, if they can come in and live also. And sometimes what we find is management will say, well, yeah, we've got a form and you need to fill out the form, take it to your doctor. We've even had a situation where management said, you fill out the form and we'll take it to your doctor. And some of the questions on the form are too specific. I would point you toward HUD.gov and the joint memo from DOJ and HUD, specifically to do with reasonable accommodation issues. There is another memo out that makes it clear the difference between service animals, which is an ADA definition, and assistance animals, which is 504, the Rehabilitation Act, and the Fair Housing Act. So assistance animals, it's a much broader definition of what should be permitted than service animal definition under ADA. And as managers, don't get caught up in looking at service animals you really probably need to focus more on the definition of assistance animals, because those are the definitions that matter under the Fair Housing Act. And again, it's very, very broad.
We gave you the list of the covered categories, and that tells you who's covered and pretty much what categories and how you become a member of them. And I said everybody's a member of the first 5, one way or the other, and some of you are members of the other 2. Now we're going to talk about what areas are covered for those individuals, and that's the markets covered. And it's a really broad definition of housing, because we're talking about access to housing or dwelling. And it covers rent, you'll see here, rental, sales, lending, insurance. It covers nursing homes. It covers shelters. It covers
Migrant
farm workers.
market front,
Their housing. It's broad.
group homes. Group homes for persons with disabilities, assisted living, very, very broad. The federal act does not specifically mention insurance. The state law does. So it is a stated market that's covered under the state law. Under the federal law, it has come to be a market that's covered, particularly when you're talking about home loans, because people really, if you're going to borrow money, the lender sure wants to know that you're going to be able to pay it back if something happens to that house. In other words, if it burns down, they still want their money, okay? And that's how it's come to be that insurance is considered a market under the Act also. We talked about this covered dwellings, but individuals that are covered, it's quite broad also. So when you're dealing with access and design under the law, you might have architects, developers, builders, contractors, engineers, landscape architects, that if they don't comply with the guidelines under the law for access and design, they are going to be found liable also. Governments, I think that's interesting too, particularly when you think about it. Are y'all familiar with the word variance? When you ask a municipality for a variance to maybe one of their codes, that's nothing really but a reasonable accommodation that you're asking of a government entity. I think we'll talk about prohibited practices as we go along. So the first section of the law is just what this says: the refusal to rent or to sell, or really to even negotiate for that, or, and here's the big one, otherwise make unavailable or deny, because of the first 6 protected classes. Persons with disability have a section exactly like this, but it's placed into a different section of the law. Anything that would constitute a violation for the first 6, as we said before, would for persons with disabilities. So, some examples.
Yeah, it's also worthwhile noting, we talked about who all is covered, and it's pretty broad. And then we talked about what kind of things are covered, and it's pretty broad, and what kind of things are prohibited is very broad also. It's obviously to just saying, no, I don't rent to, or no, I won't sell to you because you're one of the protected classes, but it also goes into all the games that might be played to get to the same point. Difference in terms. It costs more for you because you're a female, or it costs less for you because you're a Christian, or any variety of things like that. All the nuances are tried to be accomplished in the statute, and they've done a pretty good job of it, especially the last catch-all, which is anything else that makes a difference.
Yeah, and with otherwise make unavailable, you remember earlier when we talked about, or the gentleman before us talked about redlining and reverse redlining? That's conduct that would violate otherwise make unavailable or deny. Jumping over this community because of the national origin, the predominant membership of that community, to go to the community beyond that's predominantly white, to give sewer service, they pass over this community. That would violate otherwise make unavailable or deny, because it is a service that would be necessary for the people that are residing in that area, and it was not made available to them when it was made available to other people. Your sexual harassment, the quid pro quo, is otherwise make unavailable or deny. Also, refusal to rent is, the eviction is refusal to rent at that point in time. So a lot can happen even after the person does receive the dwelling. I know we've had situations where an individual rented to one person, and there were other people listed on the lease. They met that person, and when they found out who else was going to live in the house that was listed on the lease, they didn't like maybe their racial makeup, maybe they didn't like what they felt was a disability that that person had, and they'll try and get them out at that point by raising the rent. We've even had people take the doors off at points in time or change the locks. That's always a favorite of people that want to get somebody out. We'll just go in there and we'll just take the door off, or gee, if you don't want to do that, we'll change the locks. So even after making housing available, if it took longer and you grudgingly provided that housing, that's a difference in terms and conditions and otherwise making unavailable or denying housing, and would be actionable under the law. And these are just some examples, case examples. Most of them have to do with rental. The United States v. Felser really has to do with sales, where eventually the developer said, okay, I'll build the house for you. And this was after he wouldn't, and said, well, I'll build it for you over there across the track. Same house, but it's going to be over there in the African American community, because that's where this developer felt that this gentleman, who was a dean of an historically black university, needed to be. Eventually, he built the house, or he offered to build it. By that time, they didn't want it. And then the United States government proceeded against them. Difference in terms and conditions.
It's obviously wrong to say I don't rent to you or I won't sell to you because you're one of the categories. But it's also, we've shown, improper to change the terms and conditions, and also maybe even make it harder for someone because of that category. For instance, some classic examples are children, the familial status one. For instance, we will rent to you, but we have all people with children, they have this building over in the back. Or we have the folks that have disabilities over here. Or another classic in my area up in Upper East Tennessee is we rent this place for $600 a month, and you say, oh, my kids will love it. It's got 3 bedrooms, and the landlord says, you've got children? How many? He goes, 3. He goes, well, if you've got 3 children, the rent goes up to $750. That's different terms and conditions, and it's illegal under the Fair Housing Act, just like all the others. It has to be the same for given the facts. Are there any other ones that come up all the time?
And just as, sometimes you find out after you sued somebody, you'll find out on discovery some of the other little things that people did as they were trying to discriminate. And we've seen applications that had a little mark up in the corner, and that designated to the housing provider that that person maybe was African American. We've seen lists, they're running 2 separate application lists that had nothing to do with bedroom size, for instance, but just who that person was, what member of what protected class they were. You find out really a whole lot on discovery about the interesting ways that people think they can disguise treating people differently. Okay. Here you see that United States versus Felser, again, a set of facts can come under more than one causes of action under this law. And here, under Pelzer, it did. Discriminatory statements.
It also applies to advertising by word, by mouth, and by print, in short. You can't put in print that you don't rent to Christians, or you only rent to Christians. You can't be all the categories. I only rent to males, I only rent to females, I only rent to white folks, whatever. Those are all illegal. The advertising of it is an illegal act in itself. Isn't that fair?
Or something like apartment for rent. White, Christian, female, no children, no pets, which wouldn't be covered, preferred. And that gets to what I said to begin with. You might have a situation where more than one protected class is involved. And here are some cases that have that as a cause of action. Denial of availability. This used to be real popular back in the first days of the Fair Housing Act.
Yeah, you just say, I'm sorry, that unit's not available anymore. And then you go by and it's still open the next day. You don't see that as much anymore, I think, because people think they get by with it a different way. What do you think?
I think that's true. Or in a sale situation, I'm sorry, I've already sold it, and the sign will come off the house, and you wait about 6 weeks or whatever, and that sign's right back up there. Blockbusting. Really, blockbusting has to do with an agent really for profit going through a neighborhood that may have some individuals of a minority for that neighborhood that have moved in. For example, let's just say that an Hispanic couple moved into a subdivision that was 100% white. And this agent would go maybe door to door and say, did you see who moved in down the street? I'm here to help you. I can help you. I can help you sell your house. And by the way, not only can I help you get rid of this house, I can find just the house for you over there where everybody's going to be just like you. What it does is artificially change neighborhoods where everybody was happy with the individuals that maybe are of a different race moving in. It creates scare tactics that cause people to move out and others move in initially thinking that they're going to be part of a diverse community. But once this blockbusting activity occurs, they will no longer be a part of a diverse community because it's been artificially manipulated into change. There's nothing wrong with communities changing. It's when it's done artificially for profit that this law is violated. I don't know that you see this as much as now as you used to, but I can remember cases in the mid-'80s in Memphis where it was alleged an entire section of Memphis was changed by a number of real estate companies doing exactly this. And there are two examples of that. All right, now we're at those sections that relate only to persons with disabilities, and you'll see 3604F is exactly like 3604A. It's the refusal to rent, the refusal to sell, or otherwise make unavailable housing for persons with disabilities. It's interesting, though, how far this goes. It's not just the head of the household that can have the disability. It can be anybody living in the household with the disability. It can be nobody in the household has a disability, but there's some people coming over to visit that have disabilities, and management doesn't like it. And they'll say to the head of the household, if you have that person come over again, you know what's going to happen to you. You're going to be gone. Remember how broad just the definition of a disability is. You have it, you have a record of it, or you don't have it, but somebody thinks that you do. Where we've seen this carried out is the guests come over, management sees the guests and makes the assumption because they're two males together, they're gay. That is not enough for a violation of the law, but they go further and say, because you're gay, I think you are HIV positive. At that point, you have the protected class persons with disability. And if they act against the head of household because of that, then you'd have coverage under this law.
And that's true of all of the categories, too. It isn't just the person who's occupying the residence. It's they have the right to associate with who they want. And so if you have guests over that fall into one of those categories and the landlord doesn't like her or landlady and says, I don't want those types of people coming here and you're getting evicted because of it, that's every bit the violation as if you were that category yourself.
One of these cases really was brought by a white, not under this section of the law, but was brought by a white individual tenant who noticed that there were no African Americans who were shown apartments within his building or rented. And that was one of the big Supreme Court cases saying that that person's right to associate with other persons was affected, and he had a cause of action. He could sue under this law, not because he was denied housing, because he wasn't, but because he was denied the right to associate with other persons of different races by the actions of this particular management landlord. Any questions about that? Okay. Again, difference in terms and conditions because of membership in the protected class persons with disabilities. And that is exactly like what we saw before with terms and conditions that apply to the other 6 protected classes. Reasonable modification, reasonable accommodation. Do any of y'all have questions about this sometimes? Because we get a lot of questions from landlords about these issues, and particularly kind of stepping back when you have issues that are with animals, whether they're assistance animals or whether they're service animals. So if y'all have any questions about this, I think what we'll do is give some examples of it. It's specific only to persons with disabilities, and the whole idea is to put persons with disabilities, because of whatever their particular disability might be, on the same level playing field, if you will, with others who are not persons with disabilities. So, reasonable modification.
From the big picture, again, we're in the category where you've got to be disabled, first of all. Doesn't apply to anybody else, just those with disabilities. We agree that it's a broad definition of what a disability is, but you got to be disabled before this applies to you. Then you come down to modification versus accommodation, and the difference is physicality. It's the essence of something being material. Modifications are moving doorways, changing cabinet heights, putting in grab bars, putting in ramps. Those are modifications. Accommodations are changing the rules. So those are sort of this vague, you've got this rule, you're not going to do that, you're going to bend the rule for me. That's accommodation. Why is the difference between the two terms? Because the law approaches them a little bit different. One requires them to do it no matter what, and the other one says, well, you've got to allow the tenant to do it, roughly speaking. Modification is the physical one. It says that if you want to change the grab bars in a private residence that you're renting, you want to put in grab bars or put in a ramp, reasonable modification, and you're handicapped, and the ramp is necessary for you to fully enjoy the premises, then you have a right to make the landlord allow you to put one in at your cost. It has to meet standards, reasonable standards. It can't be done with a pallet and a stack of bricks. And the landlord can require you to take it down when you leave, but my experience is that doesn't happen anymore. Okay, and they changed that. That's right. But It's the physical part, and the cost is incurred by the tenant. Now, quite often, there's agencies out there that'll help tenants pay for this, but it is not the landlord's duty, although landlords will often do it because it increases the value of their property. But in the private network, that's how it works. Now, in public housing, it's different. Public housing pays for it and has to do it, but I'm talking about in the private world. Okay.
And really, just to be clear, if the ramp goes up, it becomes part of the premises, and you can't condition putting up the ramp on tearing it down when you leave. So, you know, the ramp can stay up or not, but the tenant doesn't have to pay to remove it. If the landlord wants it removed, then they can do that. And it would be the same with widening the doors, as long as it doesn't structurally affect the stability of the dwelling itself. And bear in mind that all of this has to be related to what the person's disability is, the way that Tim stated. So if I were a person, for example, let's see,
Deaf.
If I were hearing impaired and I wanted to widen the doors, what does that have to do with my being hearing impaired? Nothing. So what I'm asking to modify has to have something to do with what my disability is, okay?
And that's true in the accommodation world too, and that's where you see it more often, particularly with emotional animals and the like. You'll see folks that have disabilities, say a physical disability with the back or something, wanting an emotional pet. Those don't match.
Also, I've seen instances where, and this was really in a public housing situation, the person needed a ramp. They really needed it. It was obvious to management that they needed it. But the dwelling where she was living at that point in time, to put up the ramp, it would have had to have gone across the entrance to maybe the next door neighbors so that they couldn't get out. Therefore, although the ramp was necessary, where it was going was not reasonable. If it blocked something else so that somebody else could not get out, if it blocked the ability to get to, I don't know, the light, gas, and water meter, and you couldn't figure out a way that you could work it so that you could still see maybe the meter, then that's not going to be reasonable. The fact that it might cost a little bit of money if it's subsidized housing, that's not going to be a reason that you don't have to do it if your housing is subsidized. The fact that it's not going to look anymore like all of the pretty little houses, they're not all going to match anymore when this ramp goes up, is not a reason why the ramp can't be put up, okay? Grab bars, honestly, I'm a big fan of grab bars. I think they're pretty neat things. You can be made to take the bars down, not the studs behind them. Doors widen, don't need to be restored because they would help everybody. Reasonable accommodation.
Okay, we talked about reasonable modification was the physical stuff, and reasonable accommodations is the rules, and this is the one you see most often. You want the rules bent, an accommodation made in the rules to allow you, because you have a disability, again, you have to have the disability, you want the rules to bend to allow you to use the premises to its fullest extent for you, and those rules are stopping you from doing that, and so you're asking for them to be bent. And the landlord has to do it unless it's going to be a huge cost, or it's something so outside what they normally do in a business that it's outrageous. Those are pretty small categories is the way it comes down. So the most common one y'all see is the dog or the assigned parking spot. Those are rules. We don't have assigned parking spots. Well, I have a disability. My disability requires me to have a spot close to my unit. I would like you to break that rule that says we do not give parking spots and give me one specifically close to my unit. And they have to do that. Right. That's one example. The other things, when you get into emotional and psychological disabilities, some folks are agoraphobic, and there's a number of cases on this where they don't go outside, and they're afraid to go outside, and it's part of their disability. And they've asked that the management company come pick up the rent at their office. The rule is you got to come down to the office to pay the rent. The bending of the rule is, would you, the manager, come down and pick it up from my office because it accommodates my disability? And the courts have universally said, yes, you got to do that. And there are cases that say you've got to put off late payments of rent because my disability is how I get my check, and that's how I pay my rent. It doesn't, but the cases are, I think, are also universal that it doesn't allow you to not pay rent.
Yeah. You're going to have to pay rent. And this gets to another thing, what we discussed earlier about hoarding. And I think this is particularly true in subsidized properties, because in subsidized properties, at least once a year, there's going to be an inspection. Generally, it's at the time that the lease is renewed, to see that the unit meets the federal housing quality standards. So maintenance will, not even maintenance, I guess, it's the management will come in and go through the apartment to see whether or not it meets the federal housing quality standards. Understand that, let's just use an example of where I work, Jackson Housing Authority. They're going to send inspectors in, but there's an inspection of the inspectors, and this is true of all sorts of subsidized housing. The federal government looks at whether or not that housing provider of subsidized housing is doing exactly that. Are they inspecting and are they maintaining the federal housing quality standards? Which brings it up against reasonable accommodation. How do you, under the Fair Housing Act, do what's required under your federal regulations for housing quality standards, and at the same time comply with the Federal Fair Housing Act when you're talking about hoarding and reasonable accommodations? And I'll just give you, I can tell this because it's court record, and so I can talk about it. At one point, we had a referral of a lady to us who was living in rural development housing, and management had sought to evict her for noncompliance with the federal housing quality standards, and she was, in fact, a hoarder. She got into General Sessions Court, which is where general your evictions are there, right? General Sessions Court. She's in there, and the judge recognized what was happening, and he continued the case and actually sent her to West Tennessee Legal Services, and we looked at what her situation was. What we devised was, as a reasonable accommodation, we talked with her care provider, and we made arrangements that if there were a slip back, once she did comply with housing quality standards, once it was cleaned up, that management would get in touch with her care provider to prevent this from recurring. We also got, I don't remember whether it was a Girl Scout or Boy Scout troop or a church group that came in, and this was very difficult for her, the way that Nadine described it earlier. They came in and they cleaned everything out. She had paths. Things were clean, but they were paths throughout her apartment unit. And we requested the reasonable accommodation. I think it's important that attorneys that represent management understand about reasonable accommodation, because management's attorney didn't understand what this was about. I gave him the request, and he didn't understand the gravity of it. Interestingly enough, management did. And it made for kind of a difficult dialogue, because they wanted to talk with me, what can we do? And I'm not supposed to talk to the other side when they're represented by an attorney. So, you know, I had to say, you talk to your attorney, see if it's okay with your attorney for you to talk directly with me. And it was settled out. She got to stay. She was placed in a position through what she wanted to comply with the rules. This is not a get out of jail free, the rules being, you know, if you will, the jail. People have to comply in these situations. They have to comply. It's how you get to that compliance. And it might take a while. It might be a bumpy road. But we will talk with the individual. We'll come up with a plan that we suggest as a reasonable accommodation to management, and we go from there. It can't be something that goes on as an issue of noncompliance forever. And the court's going to say that.
The statute itself is, and that's one reason the lawyer and her opposing lawyer didn't feel comfortable with it and didn't understand it, is because this statute is quite a bit different than other statutes that lawyers deal with. It requires the two sides to cooperate. It requires them to come together to find an answer for this disability and this accommodation. There is no right and wrong answer in this case. The process is what's demanded by the statute. It says, you guys got to sit down and talk. And if you don't talk, the court's going to find against you. And there is no absolute, answer for it. Each one is different depending on what the disability is and what the accommodation requires. Although the housing quality standards, they're more an indication of how things should be. They don't actually go directly to safety. If safety is an issue, you've got a problem. But if it's just clutter and not a safety issue, HUD's going to work with you and allow that accommodation to take place.
And that's what, speaking from the perspective of a subsidized housing provider in the state housing finance agency, in your relationship with HUD, is what you've learned. In common use areas, the ability to get to the dumpster and put your trash in it, the ability to get to the common mailboxes and get your mail out or put your mail in, usable doors, which mean levers or push, not knobs, the ability to get through the door if you are in a wheelchair, and the threshold is such that you can get over it, an accessible route into and then through the dwelling unit itself. And that has to do with getting through the door, and if you will think of it as a path that goes wherever you need to go. Light switches, just as an example, if you are mobility impaired and in a wheelchair, you're not going to be able to reach higher than 48 inches. Electrical outlets, if they are lower than 15 inches, if you try and put a plug in, you're going to fall out of that wheelchair. Reinforced walls for grab bars, and then usable kitchens and bathrooms. The ability to get into the bathroom, the ability to shut the door once you're in there, the ability to turn around, the ability to get into the tub, to the lavatory, and to the toilet. And there will be, these are actually the building requirements if you are covered with 4 touching. Lending, I think we talked about that pretty much with the gentleman that spoke immediately before us. Anything that has to do with loans for residential property, and that could be the asphalt man who wants, to take a second mortgage back on your property to put in the asphalt. Threats, intimidation, coercion, particularly when you talk about sexual harassment, you're going to come under this, but any of the things that you think of as really criminal acts, burning crosses, putting graffiti on people's houses, blowing up people's car because they try to be in your neighborhood or in your neighborhood because of a particular protected class. All of these are protected under the law. This law, unlike many, has a comparable criminal statute that covers the same thing under 3631. Okay, statute of limitations.
Under the Federal Act, you have a 1-year statute for the date of the last act for a HUD complaint, and 2 years from the last date to file a lawsuit. Under the Tennessee Act, you have 180 days from the date of the last act to file a complaint with THRC, and a 1-year date from the last act to file a lawsuit. If you add those together, there's a sort of a gap problem in there. Just be aware that there's a problem and you've got different times.
Okay, complaint process. You will file a complaint with either THRC or HUD. HUD will investigate their specific regs on the time period that that's supposed to take. And then they will either determine there's cause or not cause. This isn't like EEOC where you've got to have a letter or where you have to go to the Human Rights Commission if there's a housing violation or to HUD. You can sue without any sort of letter the way you have to have under EEOC.
Yeah, you've got 3 routes to go if you have a complaint. You can go to the HUD and file a complaint. You can file directly in the state court under the state act. You can file in the federal court directly under the federal act. You can also go to HUD and then opt for those other 2 options later on.
You can get a lot of different remedies under this. Your actual damages, your punitive damages, injunctive relief. People settle these cases frequently, and there might be a component of education under them. There might be a component of notice to tenants about what the law is. Settlements can vary greatly.